Welcome everyone, this is Amer from U-Counsel. A lot of times when employees are terminated without cause in Ontario, they are unclear about their termination rights and the interplay of those termination rights. So specifically, people have questions about whether they will get employment insurance benefits if they get the severance pay, or whether if they are getting employment insurance benefits, would they still be entitled to severance pay? So that's a fundamental issue, and we'll explain that that legislative framework in this lecture, and hopefully that will help clarify this issue. We begin, as always, with our usual disclaimer that this course is not legal advice, so if you have any specific questions, you must contact a lawyer or paralegal or Law Society of Upper Canada for a referral. Now, rights on termination without cause, and this is a situation in which the employee is not terminated for cause, and if you're unclear of the difference between with cause and without cause termination, we have separate lectures on that. But briefly speaking, this is a scenario in which the employee is not being terminated because of some serious misconduct. The first kind of benefit that the employee may be entitled to is employment insurance benefit under Employment Insurance Act. There are specific requirements for the employee to be eligible, and these generally include that the employee has worked a certain number of hours, has completed a certain number of work hours, and the employee is dismissed without cause, and then he or she may be entitled to employment insurance benefits. The employee may also be entitled to termination pay under Employment Standards Act, which is based upon, again, the number of years and months the employee may have worked for that employer. The employee, in addition to termination pay, may be entitled to severance pay, which is a separate category. It's not the same as termination pay under Employment Standards Act, and it has its own qualifications for the employee to get severance pay. And then finally, the employee may be entitled to reasonable notice under common law, which is the judge-made law based upon the previous cases that the courts have decided. And so the employee may be entitled to that. And all of these entitlements depend upon the employee's length of service and the fact that the employee was dismissed without cause, and what kind of employment contract the employee has or had with the employer. Before we get into our basic question, I just wanted to explain the reasonable notice concept one more time. We have covered this in our other lectures, but fundamentally, a reasonable notice is the concept that comes from the courts. It is not based on a legislation, and if an employee is entitled to reasonable notice, then that reasonable notice already includes the termination pay and severance pay. So you don't get reasonable notice plus termination pay plus severance pay. That is not how the reasonable notice is calculated. If you're entitled to any termination pay or severance pay, then both of those kinds of payments are already included in a reasonable notice. So you got termination pay, you got severance pay, and then potentially you have some additional notice. So one example could be that, let's say, employee was entitled to 6 weeks of termination pay and 6 weeks of severance pay, and then the judge may very well, under the specific circumstances, give 6 months of additional notice, and so the total could be 7 months or so. So this reasonable notice includes all of that, and why it's important for you to keep in mind is that the discussion we're having in the next slide, if we're talking about reasonable notice, then that's probably the best case scenario for the employee. So if we use reasonable notice, then it's easy to understand the examples better. Okay, so the question then arises that if an employee is terminated, can the employee be entitled to all of those benefits that we have described above? And the answer is potentially yes. So there could be a situation where the employee gets reasonable notice plus the EI benefits. There could be a situation where the employee gets termination and or severance pay plus EI benefits, and these scenarios are possible. But you must keep in mind that these payments are not for the same time period. So the EI and reasonable notice, or EI and termination and severance pay, cannot overlap for the same time period. Let's explain that by way of an example, and hopefully that will help us clarify this question. In a normal termination without cause, these are the sequence of events that take place. The employee is terminated, and employee gets termination or severance pay or reasonable notice from the employer. And when that termination or severance pay is exhausted, EI kicks in, and then EI runs for the time period until the employee is unemployed, or about 10 months or so. That is the maximum that EI is provided. So let's say in this situation, employee is terminated January 17th, and the employer provides 5 months of reasonable notice. Then the reasonable notice kicks in, and it runs up to May 2017. That's the reasonable notice period. And then from May till, I believe, March 2018, the employee gets EI benefits. So from January, from the time that the employee is terminated, to March 18th, March of 2018, the employee gets reasonable notice and EI benefits as long as the employee is unemployed. So that's a scenario. In a normal or in an ideal world, that's how things should happen. But in majority of the cases, this middle part is the one that creates most anomalies. And what happens is, in majority of the terminations, employees either don't get any of these rights, termination, severance, or reasonable notice, or get inappropriate rights. So they're not the correct payments that they should receive, and there are different reasons for that. But majority of employment law litigation is based on this. So for instance, 80% of my practice is really trying to get employees their appropriate reasonable notice or termination and severance pay in their circumstances. And so most of the employment law litigation is either lawyers advancing employees' claims for reasonable notice, or lawyers defending their corporate clients' actions. So because of this anomaly, in the real world, majority of the people are in this scenario where they get terminated and then they start receiving EI benefits, and at some point in the future, either when they are already receiving EI benefits or EI benefits have expired, and then at some point they get through settlement or a judgment, termination, severance pay, or reasonable notice. So in this scenario then, employee is terminated January 17th, and then employee starts receiving EI right after that, and then comes the reasonable notice. So the problem with this situation is that just because this is how the sequence of events happened, this is not how the law allows these things to be tagged along. Meaning that the law does not permit that you exhaust your EI benefits and then you tag along your reasonable notice after your EI benefits. That's not how the law works. So even though the person received these termination and severance or reasonable notice after the person already started receiving EI, what the law requires is that take this payment and then insert this payment over here, right? So the law wants you to make the scenario the same as this previous slide, where the termination, severance, or reasonable notice kicks in before the EI benefits. So we move this EI, the reasonable notice before EI, but then what do we do with the EI benefits that you have already received for the same time period? And so in this scenario then, the EI will send what's called a notice of debt to the employer, to the employee, and say that you now have received 5 months, let's take the same example, 5 months of reasonable notice from January to May, but we also paid you from January to May EI benefits, so can you kindly return the money from January to May that we have paid you? Why? Because you have received EI benefits for the same time period. Okay, so you return that money, and then the EI clock is in a way reset for May 2017, right? So come May 2017, if the employee is still unemployed, then the EI kicks in again. And then it will run for another 10 months or so, as long as the employee is unemployed. And why that's important is because it all comes down to when the employee obtains employment. Because the two concepts that you want to understand in this scenario is that A, there is no overlapping double payment, right? There is potential double payment, but it can't overlap. And then you can't get EI if you are employed. So in this scenario, the advantage of moving EI again ahead of the reasonable notice period is that the clock for the employee is reset, and if the employee does have a job in May 2017, then the employee does not get any more EI benefits. So then the reasonable notice that the employee had received makes the employee whole up to May 2017, and thereon the employee has a job. So that's the end of it. But if the employee still does not have a job, then he or she is entitled to EI benefits, and that can run for the reasonable notice period. So the key things that you want to remember is that there is a potential for getting all of these payments. You can get all of these payments, but you must keep in mind that they do not overlap for the time period. And what you also want to understand is that this concept comes from two legislation. One is the Employment Insurance Act, and second is the Employment Standards Act, and then of course the common law, the judge's law. So hopefully that helps you understand under what circumstances you can get EI benefits and severance payment, and under what circumstances you don't. But if you are unclear about any of these concepts, or if you have any questions or any feedback, we'll appreciate to hear from you, and thank you for watching.